So, Minister of Agriculture, Land Reform and Rural Development, Thoko Didiza, is currently briefing the media with regards to the Presidential Expert Advisory Panel on Land. Let's go there now live. Oh, they're still setting up now. But let me just give you some context around this briefing. Cabinet has received this final report. Remember, it was the panel was appointed back in September 2018 to provide this unified perspective, this policy perspective on land reform. We're going to hear much more with regards to that. The Minister in the Presidency, Jackson Mthembu, when he was briefing the media, said that cabinet ministers have been directed to study this report and the final report of the Presidential Expert Advisory Panel on Land Reform and Agriculture and get back to Cabinet within 2 months. So it's a very, very important policy, report dealing with a unified perspective in terms of policy. Let's go there now live.
A decision was taken that the panel members of the expert panel advisory must have the media briefing to unpack the report that was presented to Cabinet. Here to present is led by the Minister of Agriculture and Land Reform, Minister Thoko Didiza, and there's also a panel chair, Dr. Mahlati, supported by the other members, Ms. Bulelwa Mabasa and Mr. Wandile Shobo. And then on the extreme is the Acting Director General of the Department, Randani Sadike. And it's over to you, Minister.
Thank you very much, Publa. Good morning, ladies and gentlemen, here in Pretoria and in Cape Town. Chairperson, members of the media present, it is a pleasure that today we formally table the report of the Presidential Advisory Panel on Land and Agriculture. It is our hope that as men and women who communicate widely with society, you will be empowered to do so, having been briefed by the panel who worked on this important issue that is topical in South Africa's political and economic landscape. President Ramaphosa, both in his first State of the Nation address in 2018 February and June 2019, emphasized the importance of dealing with the land issue in our country. In addressing the land question, government is not only addressing the historical legacy of dispossession, but at the same time recognize the multifaceted role of land in the economy of the country as well as social development. Speedy delivery of land for human settlement as announced by President will not only provide our people with houses as assets, but also will ensure integrated spatial planning where we can work towards deracializing our communities. Since 2017, ANC Nazareth Conference, where the governing party pronounced their resolution on land, particularly having expropriation without compensation as one of the mechanisms, we have experienced a lot of conversation in our society, and in particular, our parliamentary process of constitutional review, which saw many of our people participating in reflecting whether or not Section 25 needs amendment. The President appointed the Interministerial Committee on Land Reform, chaired by the Deputy President, to ensure that our land reform program is coordinated and fast-tracked. The committee has undertaken a lot of work in this regard. In introducing the panel, seated here in front of you as well as in Cape Town, I wish to inform members of the media that President appointed the Advisory Panel on Land and Agriculture in September 2018. The terms of reference of the panel are in the report and will be tabled by the chairperson when she tables the report. But in the main, it was to propose a unified policy perspective on land reform under the Constitution and applicable legislation. The panel was also to advise government on circumstances in which policy on expropriation without compensation, if agreed to, will be implemented, what procedures will be followed, and institutions to enforce, as well as the rights of those that will be affected, including the rights of judicial review. In essence, this process of the panel can be seen as reviewing what we have currently and also looking forward in anticipation of what could be when the Constitution is amended. The panel will outline the processes and methodology that they followed in undertaking this task, which has resulted in the report that they will present to you today. After completing their task, the panel presented their report to the President, the Interministerial Committee, as well as Cabinet. Cabinet has noted the report of the panel and referred it to the departments for analysis and identification of action plans that they will present to the IMC and then to Cabinet for adoption and execution. Cabinet has decided to publish the report of the panel for public consumption. As we speak now, the report can be sourced from our departmental website as well as the GCIS website. I also want to indicate that in presenting the report, the panel did advise us that out of the members of the panel, 2 members on some of the, or rather parts of the report, they had different perspectives, and therefore they have what they call alternative perspectives on that report. And they will, I'm informed as of yesterday, decided that they were not going to be part of today's session, but they would also make their own alternative perspective public. On behalf of Cabinet, we appreciate and thank the advisory panel for the work done and in the speed in which they've completed this task. I therefore wish to present the advisory panel to you and hand over to you, Dr. Mahlati, through the chairperson, of course, to take you through their report. Thank you.
Thank you very much. Over to you, Dr. Mahlati. I just forgot to mention the 2 other panel members that are in Cape Town.
Thank you, Honorable Minister Didiza, and Honorable Chair. Am I honorable in you now? Ms. Phumla Williams of GCIS. I also would like to recognize the acting DG of the Department of Land Reform. I'd like to recognize our members who are here with us of the panel, as indicated, Ms. Bulelwa Mabasa here, as well as Mr. Wandile Sihlobo. In Cape Town, we have both the professors, Professor Muhammad Karan, as well as Professor Ruth Hall. So they are all part of us this morning. It is with great pleasure to be here this morning after such hard work. And I just want to read the statement to give a sense of what the report that we are today talking about is focusing on. The Presidential Advisory Panel on Land Reform and Agriculture was appointed by His Excellency President Cyril Matamela Ramaphosa on 26 September 2018 to provide a unified policy perspective on land reform and independent advice to the Interministerial Committee chaired by His Excellency Deputy President David Mabuza. Panel members brought a diversity of skills, experience, as well as expertise in matters related to land reform policy, practice, and research, urban and rural development policy and planning, land reform law, agricultural economics, farming, and agribusiness. The Minister referred to the terms of reference, which cover a broad spectrum of land reform issues in rural and urban areas. We like to emphasize this because our work was not just about Section 25. We had to deal with issues that include the consideration of agrarian reform and addressing spatial inequality. The mandate was partly informed by the resolution of Parliament to consider expropriation of land without compensation. However, the panel's role is distinct from and does not duplicate the role of the Parliament's constitutional review. Our focus has been on the circumstances in which the policy should be applied, the procedures to be followed, and the institutions to implement and enforce. Considering the complexity and the emotive nature of land reform, the panel applied evidence-based approaches, pivoting discussions and the report on historical truths and grounded facts. So there were difficult discussions amongst ourselves, but we're very disciplined in terms of nobody just says, I think and wish. it had to be evidence-based. Various reports that had diagnosed and vigorously analyzed the problems and failure of land reform were considered to build a sound basis for the recommendations that we'll be sharing with you today. As instructed by our terms of reference, these were followed up by a series of consultative processes. Within government, we met with the ministers within the Interministerial Committee as part of the 5th Administration, heads of department, Land Claims Commission, Office of the Valuer General. We also had 2 colloquia where we had included various parties from government, different spheres of government, parliamentarians, civil society, private sector, academics, legal and foreign experts. And these were followed by 10 roundtables where we specifically included various topics with different parties from these constituencies. In recognition of the magnitude of the responsibility placed on our shoulders, it was incumbent on each member of the panel to always be mindful of and hear the cries of the majority of our ancestors who were dispossessed of the land and of their birth through bloodshed and untold pain, but to also be mindful of the hopes and dreams of our future generations for a just, prosperous, stable, and egalitarian country. In essence, therefore, the premise of the work undertaken by the panel is the firm belief that land reform could enable social cohesion, deliver social justice, and restore dignity to the majority of the people of our country. We also believe that land reform can contribute to inclusive growth and sustainable development. It is thus far with great humility and pride that we are today with the Minister announcing the official approval of the report being noted by Cabinet, and this is the final report of the Presidential Advisory Panel on Land Reform and Agriculture, and the report is dated the 4th of May 2019. The Cabinet approval on 24 July 2019, which has resulted in this report being made public in Cape Town, follows the handover of the report to His Excellency President Ramaphosa, Deputy President David Mabuza, and the presentation to the 6th Administration Interministerial Committee on Land Reform. The panel wishes to emphasize and encourage each citizen and all sectors of society to read the report, not just as a policy position, but a crucial resource which will contribute to land reform, spatial transformation, and agricultural development policy formulation. The panel also expresses its gratitude and honor bestowed upon it to serve the people of South Africa. It is our hope that the recommendations contained in the report will contribute positively to expedite and sustainably deliver land reform objectives as directed by the Constitution. Before highlighting the key recommendations, it is incumbent on us to draw the public's attention to areas of disagreement which are included in the report on page 102. Our terms of reference were instructive in terms of us highlighting these areas of disagreement. These were registered primarily by Mr. Dan Creek and Mr. Nick Serfontaine. They mainly cover, but are not limited to, expropriation without compensation and amendment of the Constitution. So I will just now briefly touch on some of the recommendations, and as we look at that, we say, this is the time, Kinago. Our country has reached the precipice, we believe, and it is the hope of the panel that land reform can no longer elude us, as it forms a critical and central place within the Bill of Rights. Critical issues such as land hunger, insecurity of tenure, with majority of land rights that are not legally recognized nor registered in both rural and urban areas, are threatening stability, inclusive growth, and development. The land reform trajectory requires, we believe, a radical shift, as 80% of urban dwellers, including peri-urban, reside on 2% of land, with targets for transferring commercial agricultural land 30% by 2014 not being reached, even half of that. We are informed that we are hovering around 10%. This is exacerbated by the reluctance, we believe, by government to address communal tenure and underdevelopment of communal areas, perpetuating the marginalization of women, the rural poor, and communal farmers in general. The report provides recommendations for immediate action. These include immediate allocation of land, building on and refocusing private partnerships, and strengthening of food systems and rural-urban linkages. The report further calls for a consolidated national land reform policy framework with a new white paper that addresses the current gaps to include urban land, address spatial transformation, and climate change. The framework must also add land administration as a fourth pillar, retaining and strengthening land restitution, redistribution, and tenure as indicated in 1997 National Land Policy. So, in these recommendations, the panel calls for the following: expediting and refocusing land reform to address inequality and historical injustices. South Africa has made world headlines as the most unequal country. The report attributes the persisting inequalities to the manner in which land is owned, managed, and transacted, with approaches that have not addressed historical injustices, contributing to deepening of structural poverty and inequality, particularly as far as racial, spatial, and gender is concerned. Of concern is the transactional as opposed to the transformational nature of land reform riddled with corruption. The panel's report urges the President and his cabinet to expedite the land reform process, use all its existing powers to deliver land reform, and reorient it towards meeting the most urgent needs first, to resolve the outstanding land restitution claims, to release acquired private land, state-owned land, and to much more effectively identify privately owned land needed for redistribution. The report further provides beneficiary selection guidelines to promote transparency, addressing the urgent need for human settlements, providing access to land for the landless, household food security, emerging black farmers, industrialists, and entrepreneurs. As far as land expropriation without compensation, the majority of the panel members endorse the proposed policy shift towards using the provisions of the Constitution to expropriate land without compensation. The majority view in the panel is that it is an inescapable fact that Section 25 of the Constitution is compensation-centric. In other words, the notion and origin of expropriation draws from global examples where it is inextricably linked with some form of compensation. The panel has therefore offered a proposal for a constitutional amendment that clarifies that expropriation without compensation may be necessary in limited circumstances, and we do indicate what those circumstances are, but certainly in order to elevate the objectives of land reform. The state is already empowered under Section 25 of the Constitution to expropriate land for land reform purposes, but is required to pay just and equitable compensation. Whether and when such compensation can be at zero has been the subject of debate over the past 18 months within our country. There were differing views within the panel as to the necessity for constitutional amendment. Parliament has already voted to amend the Constitution, and a committee has been established to propose the nature of such an amendment. We have suggested some wording that would serve as a clarification that compensation may be zero in circumstances that justify this as obliged by the panel's terms of reference. The panel was further concerned about the current and previous land acquisition transactions that did not adhere to the Constitution, as it allows for expropriation with just and equitable compensation. Part of the problem was the use of the 1975 Expropriation Act that precedes 1996 Constitution and the poor capacity of the Office of the Valuer General's Office that still uses the market value. Although the current framing of Section 25 does not inhibit the state from expropriating land, this report assists by identifying those specific conditions under which land may be expropriated without compensation. And the panel recommends that these circumstances be part of the expropriation bill and further detailed in a compensation policy. That's a motor. Excuse me. We proceed now to look at other areas, and I'll touch briefly on them. As far as land redistribution, this is an area we believe has not managed to get the right attention and priority, including resourcing by government, which forms part of the problem of failure of land reform. We propose a proactive, targeted, area-based approach. And within this, we actually indicate that land redistribution should no longer be dependent on willing buyers, willing sellers, offering the land for sale. Instead, we believe and propose that government should pursue a more proactive, targeted acquisition of land identified as needed. What is critical about this is that this offers space for integrated planning within a given area with a specific focus on understanding and analyzing the agroecological potential of the area with land use options. So the land identification and acquisition should happen at municipal level in a participatory and democratic manner to specify the land parcels required to meet the identified needs. The Constitution's property clause requires that all citizens should have access to land on an equitable basis. In our view, this requires that those who have the most urgent needs should get priority. We also propose that beneficiary selection processes be strengthened and made more transparent, consistent with the UN as well as the African Union frameworks. This should address corruption in the land allocation process, and it should assist in clarifying who should benefit. I now move to the next issue of the land acquisition. This is an important part because expropriation without compensation is also one lever and a strategy as far as land acquisition is concerned. And it is because of this that we continue to say land reform is not just equals expropriation without compensation. Expropriation without compensation is an acquisition method. So we believe that the new white paper must specify the range of land acquisition methods that will be pursued for land identified as required for land redistribution or restitution. Important as well is the call for land donations. During our process, we met as part of the consultation with various owners that include the mining houses, the churches, as well as the farmers. And the idea here was also supported by some of them who had tried to donate land but experienced problems. So we're calling now for this to be included and enabled, but with a very specific land donation policy. Part of this is also to accommodate negotiated acquisition, as well as, obviously, the expropriation, which we highlighted earlier. Now, in talking to the area of land donations, we recommend that government develop a donations policy which encourages landowners to donate properties or part of their properties by offering exemptions from donation tax and carrying the conveyancing costs of land transfer. So part of the proposal is to call on the churches, mining houses, financial institutions, agribusinesses, and others to themselves audit their own land holdings to identify land that they can donate and start the negotiations with the various government bodies. We also suggest that the minister convene within the coming year talks across these sectors to secure these donations and to open discussion with potential beneficiaries, including existing land occupiers such as farm dwellers and labor tenants. Another critical part is the financing of land reform. We have been concerned by the current budgets for land reform and recognize that government alone can never be able to address these. We require partnerships. And part of this is the proposal of the establishment of a land reform fund which will bring together state and private finance to support land reform. Our hope is that this will get buy-in, but we need to make sure that there is broad buy-in through consultations and mobilization, and the financial support from the state, which includes restructuring of the land bank and possibly looking at incentives for private sector contribution. We also are calling on donors to also participate in this process, because it is important that people globally have to appreciate the importance of supporting this initiative for the stability of South Africa and impact on others. The restitution is one of the arms of land reform, and it has been the one that focus and resources have been applied and really focused on. The Commission on the Restitution of Land Rights, we believe, must prioritize the settlement of old order claims that were submitted by the first deadline of 31 December 1998, as required by the Constitutional Court. The Minister is urged to instruct her department to expedite claims also via redistribution, where claimants should be able to opt for land redistribution or tenure security options to avoid the onerous requirements of having to prove how and when they or their ancestors were dispossessed in the past. The minister should also use her discretionary authority to address legitimate claims which fall outside the eligibility criteria of the Restitution of Land Rights Act, such as the Khoisan and other pre-1913 claims, via land redistribution. This means that people who were previously excluded can now be included. We recognize the need to strengthen the capacity of the Commission with additional staff and training, and call on government to do its utmost within its resources to make this happen. Critical for us is the Land Claims Court. This is a sad reality of a land claim court which 25 years on still has an acting judge. We call for the reform of the Land Claims Court. It has not performed the functions for which it was established, and has not been functioning optimally and has not had one permanent judge. It should be reformed and its mandate expanded and clarified. And this includes the area of conflict resolution and mediation. To reflect this change, it should be renamed, we propose, the Land Court, to reflect its broad oversight over all land reform matters. Another critical area for us is the importance of addressing land corruption. We note with concern the growing evidence and instances of corruption in the acquisition, allocation, and transactions of land. We have identified 5 different types of land acquisition corruption, which touch across all sectors of society. We urge government to take steps to improve oversight and more investigation and prosecutions to stop land-related corruption in all its forms. The department must tighten up the beneficiary selection process to reduce the scope for corruption. Selection and allocation processes must be more transparent, and there must be greater openness and accountability as to how these decisions were arrived at. We call also on the government to establish an office of a land rights protector as an ombudsperson who can investigate allegations of corruption and, where appropriate, refer cases to the National Prosecution Authority for prosecution. In terms of farm workers and dwellers, we call for an end to farm evictions and urgently expedite mechanism to secure farm dwellers' tenure rights in line with the law. We recommend that the Minister instructs the department to urgently create an application system for farm dwellers to upgrade their tenure and expand land occupation, as provided in Section 4 of the Extension of Security of Tenure Act. When eviction applications are heard in the courts, municipalities must be required to propose on-site settlement options for farm dwellers. National government must review the farm schools policy to ensure the right to education for children residing on farms. And also the subsystem must be reformed so that illegal evictions and violations of Section 23 of ESTA are registered as criminal offenses. Police, prosecutors, magistrates, and attorneys in the Land of Rights Management Facility panel all need training and mentoring by a dedicated training team emphasizing alternative dispute resolution. As far as the labor tenants are concerned, we propose that labor tenants must be a priority group to benefit from land reform. We have specifically recognized the vulnerability of particularly those located in KwaZulu-Natal and Mpumalanga, where these are black farming families already living on and farming the land. They are entitled to upgrade and secure their land rights, and we would urge government to address these issues. We call on the department to finalize the database of applications under the Land Reform Labor Tenants of 1996 and prepare a proper time-bound, costed, and publicly available plan for implementation. We call on Parliament to monitor implementation of this plan and to amend regulations to the Act to address overlapping labor tenant and restitution claims. Those whose claims have been lost must have the opportunity to resubmit, and the department must identify claims where expropriation may be used to break deadlock with owners, subdividing where appropriate, and test just and equitable provisions in the Constitution to acquire and transfer this land to the claimants. Beyond these main areas we also identified what we call game changers that can give added meaning to the land reform process and benefit a wider population. Of importance is the area of tenure reform. The panel proposes a bold new approach to recognizing and recording the diverse range of tenure rights that exist within South Africa. This for us is an important issue because we sit within a country where over 60% of the land rights of the population are not recognized, nor recorded or registered. Whilst apartheid laws and regulations created a racialized hierarchy of rights, we endorse the principles underpinning tenure reform in the White Paper of 1997, including legally enforceable rights based on recognizing the de facto vested rights that exist on the ground. In other words, people who by tradition are occupiers and owners of land must be recognized as such in law. We urge government to avoid private titling of communal land, which is inappropriate to customary forms of tenure. And we thus proposed a mixed tenure reform regime that recognized both private titling as well as communal. Rather, the panel recommends a land records bill which will enable the majority of citizens who hold property off register to record and register their property in order to address the issue of the estimated 60% that I referred to. These include residents of informal settlements, peri-urban areas, farm dwellers, rural communal areas, labor tenants, and others. As far as land administration, we recommend that land administration be recognized as a fourth pillar of land reform. At the heart of this is the organization of the data and alignment and reconfiguration of land administration in South Africa. Alongside restitution, redistribution, and tenure reform, we want to add land administration. This is needed to ensure that all people's land rights are well governed and administered. We call on government to appoint a working group to drive this process, set up an integrated land information system, and appoint researchers to work with state officials to identify priority testing areas, such as the areas highlighted above in terms of former homelands, informal settlements, and others, and to advise on how to scale up improved land administration. The intended outcome of these initiatives is a revitalized, integrated, and unified land administration system that provides a legal and institutional infrastructure for all land-related management and rights. Another critical part, which we believe as part of the new land reform strategy, is focus on urban land reform. We propose that land reform be extended to urban areas with the aim of building inclusive towns and cities where all residents have equitable and secure access to land for housing, businesses, recreation, and other uses. We call on government to develop an urban land reform policy and to take proactive steps to audit and redistribute well-located, vacant, underutilized, or inefficiently used urban land and buildings, including state-owned and state-leased land, that can contribute to overcoming this apartheid spatial inequality, to prioritize the social, historic, and transformative value of land over its capital asset value in decisions relating to the use, the lease, transfer, and disposal of land owned by the state and state-owned enterprises. Therefore, government must respond to the growth of informal settlements and inner city occupations where land or property is already settled. By recording of registrar, less formal land rights, and providing occupiers with proof of residence and providing alternative accommodation where evictions leads to homelessness, including in the form of affordable rental programs in well-located areas. Another area that we believe is critical as a game changer is focus on institutional arrangements. The issue of a capable state cannot be overemphasized in addressing land reform. The weakness within the state at all levels is part and parcel of the problems that we're experiencing. We recognize that the institutions charged with implementing land reform have faced numerous challenges, and these are long-standing problems with coordination amongst institutions. First, we propose that government should transfer responsibility of rural development away from the department. This is something that basically we feel that the department should focus on land reform, and land reform that touches on all aspects of urban and rural and different sectors as far as land use is concerned. We believe that rural development is a coordinating function and also not just a line function, because rural development involves issues of rural infrastructure, rural economies across sectors, not just agriculture. Second, we call on government to establish a land and agrarian reform agency, combining land reform and agriculture functions and directorates from the two departments. And we propose the settled restitution claims be transferred from the Commission to this agency for implementation, because there is a very complex function beyond just the transfer of land. And this is now getting into transaction advice and ensuring the use of the land. We've recognized that very often the department as well as the Commission does not have such capacity, and we believe that we need to address this to make sure that land reform succeed. So in conclusion, it must be noted that these are not all the recommendations that are contained in the report. We talk about water, we talk about climate change, we talk about access for women, and all these are contained in the report. The panel will also publish a summary of recommendations for ease of reference that will detail the sum total of all recommendations made. We look forward to engaging with the public as we assist with the implementation of the recommendations of the report through government. Thank you so much for honoring us this morning.
Thank you, Dr. At this point, we will allow questions, and I will start with Cape Town. Are there any questions from Cape Town?
Is this still Marianne? Good morning, everybody. Marianne Merton, Daily Maverick. To the Minister, first of all, in terms of the cabinet discussions last week, is there, first of all, an overall agreement that what the panel recommended will be implemented? Or is the 2-month period that was granted to various ministers to revert back a kind of waiting period to see what if and possibly pick and choosing what could be implemented? Two, we've had 2 white papers, the one correctly in 1997, but we've had a huge white paper process around about 12 years ago. That white paper process was never implemented, with the exception of the law on the Valuer General. If you're now talking on another white paper policy, white paper process, excuse me, what are the time frames? What are we looking at? If I may ask the chairperson of the panel or anyone from the panel to talk a little bit wider on the communal land tenure proposals and recommendations. You stated that over 60% of South Africans live and are simply not titled in any ways and forms. We do know politically the National House of Traditional Leaders has already opposed anything except traditional leaders and traditional houses being in charge of communal areas. There are politics involved in the sense that the ANC, the governing party, has a certain liaison with traditional leaders. How do you propose that unfolds, particularly the communal land tenure rights legislation that was supposed to have been reformed over 5 years ago? Still hasn't come before Parliament. And then if you would please talk also a little bit more about the role of women in the land reform that you are envisioning. Thank you.
Good morning, Jan Gaarder, News 24. First question, did you have make any recommendations or findings regarding nationalisation? I'm asking because a lot of people seem to equate expropriation without compensation to nationalisation, and also the EFF proposes nationalisation of all land. And secondly, if I understood correctly, suggest that acquisition of land for redistribution should take place on a municipal level. Now, South African municipalities, a lot of them have serious capacity challenges and management personalities. So you can perhaps elaborate on the reasoning for that. Thanks.
There's one more question to follow.
Hello? Is it still coming? The last question?
Yes. Sorry, she's just putting on. Susan Seeger from Noseweek magazine. Could you expand on which categories of land should be expropriated without compensation? And could you also give us some indication of the categories of land reform related corruption that you spoke about?
Thank you very much.
Sorry about that. There's one more.
I note that you make recommendations regarding the Ingonyama Trust, that the trust should be disbanded or at least dramatically restructured and more governance built into it. This is a question for the Minister. The President has spoken about this. What is the government's position on the Ingonyama Trust?
Thank you. Can we take a round over each time? Yes. And then, and then
in terms of the donation of land, which you spoke about, can you just give us clarity on what you mean about donation of land in order for there to be some sort of negotiation? You mentioned something along those lines.
yes, Kai.
Hi, good day. It's Kaya here from EMCA. Just to get a sense in terms...
Sorry, Kaya. Can the mic at the back, switch off the mic at the back? Yeah, then Kaya, you're fine.
All right, thank you so much. Maybe just to get a sense from the panel itself, in terms of the expropriation of land without compensation, is there a sense that we can have a unified policy that we can implement in the country? Because what has always been a guideline is making sure that food security is not also destabilized. So were we able to perhaps get a sense that we can have a unified policy that we can implement and make sure that the land is given out? But also another question is around the financing scheme that you proposed. Do you have an amount perhaps that you can just put down, or is it still too early to tell? Thank you.
Yes, at the back.
A question to the Minister.
Which publication is from?
I'm Nico from Bureau Atlantis Newspaper. To what extent will the minority report be considered by the department and also by cabinet?
Thank you. I think that's about it, Chair.
Okay. Thank you so much. I think I'm going to allow the Minister first.
Things that you've got
Oh,
more
should we?
questions.
Okay. So I'm going to ask the different members of the panel to address the questions. I'll start with Ms. Bulelwa Mabasa.
Marion from Cape Town, Marion Tam, you asked about whether or not these recommendations...
Sorry, it's Marion Merton. Thank you.
Sorry about that, Marion. You asked about whether or not these recommendations would be implemented. Well, as you are aware, we were appointed on the basis of our independent advice, and the President, together with his IMC and Cabinet, are well within their rights to decide what it is from the recommendations that will align with their plans on the issue of the recommendations. On the issue of communal tenure, you asked about, to speak wider about communal tenure. I think there's a recognition by the panel that within communal tenure sits cultural and traditional practices that we don't believe we should have the complete autonomy to eradicate or even do away with. What the panel does propose for, though, is that there should be a sense of ownership of rights by occupiers themselves. The panel does not believe in this dualistic form of a hierarchy of rights that were formed by the apartheid states between the urban and communal tenure. In fact, the panel believes that we shouldn't create an artificial distinction between urban and communal tenure. The fact of the matter is that we've got more than 60% of our population either with very little tenure or no tenure at all. So we are advocating for a restructuring even of our legal recognition processes, where our law should also recognize rights that are currently unregisterable. As we speak right now, our property laws recognize only those types of real rights that only protect those that are formal rights owners, like landowners and so on. So what we propose is a mixed tenure regime that will ensure that people are able to have rights that are legally recognizable and registrable in order to include the majority of the country. Jan Gerde, I'm sorry, I am probably butchering your name, but please forgive me, from News 24. You asked a question around nationalization and whether or not the panel dealt with nationalization. The panel's understanding of the law is that our constitution does not make provision for nationalization. And we did consider some legal precedents, including the Agri-SA case that dealt with the minerals. We therefore believe that nationalization is not on the cards with the current framing of the Constitution. What the panel recommends, however, is that the circumstances that warrant expropriation without compensation should be clarified in a secondary bill such as the expropriation bill.
Okay.
Thank you. I think I'll allow some panel members to respond to some of the other questions.
Okay, let's go to Cape Town, to panel members there.
Thank you very much for those questions. To add on the issue of communal tenure, we were concerned that 25 years into democracy, that approximately 30% of our population who are resident in the former Bantustans in the communal areas still do not have secured tenure rights in law or in practice. We're concerned in our report about several proposed laws that would affect the land rights of these people living in the communal areas. These include the Traditional and Khoisan Leadership Bill and several others. Our view is that these proposed laws could reinforce and extend the powers of traditional authorities over customary and family land and resource rights, and negatively affect the rights of residents, potentially exposing them to lose their land without their free, prior and informed consent. South Africa is a one unitary state where everyone has the right to equal citizenship, and the law should recognize that land rights vest in the occupiers and not in institutions like traditional councils. We urge the government to take steps to earnestly engage with the many millions of people who would be affected by these proposed laws. And we urge government to develop a Protection of Informal Land Rights Act to protect them. This also will require the amendment of the Mineral and Petroleum Resources Development Act and the Marine Living Resources Act to clarify that customary rights coexist with rights awarded under these laws and cannot be extinguished by them. This means that people cannot be dispossessed without their consent to make way for mining or fishing or other commercial investments. We further call on the government to urgently address the situation of the Ingonyama Trust and regularize the rights of occupiers in the former Bantustan of KwaZulu, so that they are equivalent to the rights and status of occupiers on other communal land. In the report, we indicate that on the basis of our extensive consultations, including with residents of the Ingonyama Trust, we recommend that either the Ingonyama Trust Act should be repealed and the trust disbanded entirely, or the act must be reviewed and land governance should be devolved to the local level so that rights vest in occupiers and governance functions resting with the traditional councils. On the issue of land expropriation without compensation, there was a question as to what are the circumstances under which this could be considered. The current expropriation bill in section 12.3 provides for 5 different circumstances in which there could be no compensation. We have expanded this potential list and recommend 10 potential categories in which there could be expropriation without compensation. These are listed in the report. Briefly, they are abandoned land, hopelessly indebted land, land held purely for speculative purposes, unutilized land held by state entities, land obtained through criminal activity, land that is already occupied and used by labor tenants and former labor tenants, informal settlement areas, inner city buildings with absentee landlords, land donations, and farm equity schemes where the state has purchased equity and there have been no or limited benefits derived by worker shareholders. We propose that there should be a new compensation policy developed that would clarify when and how compensation would be paid. This compensation policy should provide a typology of situations and define a compensation spectrum ranging from zero compensation in some situations to minimal compensation, substantial compensation, and cases where there should be market-related compensation. And we feel that this will provide some guidelines also to the work of the Officer of the Valuer General. The third point that I would like to add is on this question of land redistribution and the beneficiary selection criteria. We noted, as the chairperson of our panel has indicated, with concern that most land reform to date has benefited men rather than women. We propose in our report that at least 50% of beneficiaries should be women, and at least 50% of the limited state resources available for land reform should go to women. We further call on government to refocus land redistribution on meeting the needs of the poor, while also providing support to black emerging entrepreneurs and the so-called missing middle who don't qualify for financing methods. We therefore propose that the available funds and land be allocated to 4 categories of beneficiaries as follows: 30% to the poor, to farm dwellers, labor tenants, and subsistence farmers; 30% to smallholder farmers producing for local markets; 30% to medium-scale emerging commercial farmers; and 10% to large-scale established farmers who are better situated than the poor to contribute their own capital and to leverage finance from the land bank, commercial banks, and other financing institutions. Thank you so much. Sorry, to introduce myself, I'm Professor Ruth Hall from the University of the Western Cape.
Thank you. I'm going to ask that Professor Karan, if he wants to add, before we go to Mr. Slob.
I can maybe respond to the issue of implementation at local or municipal level, and the question related to does adequate capacity exist at municipal level to handle land reform. Now, the proposal is made more or less in line with what the National Development Plan has proposed for district-based planning, area-based planning, and agroecological specificity. We see that as a multi-stakeholder engagement, of which municipalities will be part, but all other stakeholders, including government departments in terms of their land management, as well as landowners and potential beneficiaries and others, should participate as a multi-stakeholder approach. And there are examples in this country where this is already exists. So it's not primarily or entirely rather the responsibility of local municipalities. I would maybe start a response on the question on financing and how much would be available, and then ask my colleague Wandile to also maybe add to that. It is difficult to determine a precise target for number of hectares or amount of money required for land reform, because much of that depends on how much can be obtained from the state, how much can be obtained from the private sector, how much can be obtained through land donations and other mechanisms as proposed in the report. What we can say emphatically though is that to achieve the land reform targets, simply with contributions, financial contributions by government is not going to reach that target, with or without expropriation, without compensation. Contributions are required from the private sector and from the financial sector to be able to reach those targets. And those, the outcome of those can only be determined once those schemes have been devised and implemented. Thank you.
Thank you. Wandile.
Thanks, Madam Chair, for that. On the question of the cost and how much will be needed for the fund, Kaya, the money is needed for two things. For the purchasing of the land, but also for utilizing the land thereafter. If it's for farming, there's going to be a need for post-transfer support. Now, obviously, as Prof. Karan is saying, that it's difficult to come up with the exact figure, but what we were working with, we were saying if the state numbers are saying we're hovering around about 10%, and we're wanting to say by 2030 we're trying to get to 30% of the land, how much capital would we need for both, for post-transfer support and acquisition of the land to get there? And the estimates that we're sitting with at this point is at least a minimum of about 240 billion rand. Now, to get that, obviously, the state might not have a bigger muscle to pull that up, which is why we're encouraging the private sector participation on blended finance and also land donation and the other facilities which will assist in building up that fund, and then hopefully we will deliver to the promise of land reform. Thanks.
Just adding on the land reform fund, it's important to understand that currently we're having a serious crisis as far as funding of particularly land reform and agriculture. And we talk about the whole reconfiguration of financing, because at this stage we're sitting with land bank where over 80% of the book is funding for white farmers 25 years after our democratic dispensation. So we're talking here at a form of financing that starts to address microfinance at that level and having conversations with financial institutions to also recognize some of the proposals we're putting forward. For instance, in discussions with the traditional leaders and occupants in communal areas, we have the appreciation that there is a separation of the homestead from the productive use of land in terms of amasemi, and there is now a recognition of pushing the permission to occupy to accommodate for longer leases for commercial purposes, to make sure that you protect the land rights, but at the same time you create space for a form of tenure that allows for people to transact. And as far as that is concerned, we're having serious concerns in terms of the marginalization of the majority of black people, black farmers, entrepreneurs, particularly women in all these areas. So when we talk about land reform fund, we are actually looking at an overhaul and a different approach that touches both state institutions as well as conversation with commercial institutions so that we can say, le rona le batho. People are also bankable and they need to be accommodated. I'm going to hand over to the Minister. Oh, yes, you wanted to deal with...
Yes, there was a question, I think it was one of the last questions, on some clarity on the issue of land donations. What the panel is doing or at least the premise of the panel, is that we are actually urging the good faith and the goodwill of South Africans to unify behind land reform, not as a divisive issue. And as much as we understand that the basis of it is based on emotion, we want to move forward to say the responsibility to deliver land reform, as much as it's a constitutional obligation of the state, that it should involve each sector of society, and that we believe that it is within the ability of South African society to really behind this land reform program. And we urge each sector of society to find it within their small spaces that they occupy to contribute to this program. So we see land reform as a potential issue for social cohesion, no longer as a divisive issue for the country. Thanks.
Thank you very much. Is it audible?
Yeah.
Okay. Thank you very much. There was a question asked about Cabinet's response to the report. I indicated when I was giving opening remarks that the Cabinet noted the report, decided to refer it to all departments for analysis and identification of what is implementable. And the reason for that, I'm sure you have noted in the report that some of the recommendations cuts across various ministries and not only in the purview of land reform and agricultural department. For instance, if you look at the issue that the panel is raising on the donations policy and what incentive the state might give, that relates to issues of taxation, which are not in the purview of the Ministry of Agriculture. If you look at the issue of urban land reform, that will touch largely on the Ministry of Human Settlement, Water Affairs and Sanitation. So if you look again on the issue of the land court, the land claims court and the proposal that it must be a land court, it actually redefines completely the land claims court as we know it today, because you then have to redefine the seat of that court, where it fits in the levels of the courts that we have today, its administration, the permanency of judges, because the way currently the land claims court operates, it actually has got judges that get seconded from the High Court, but also it's a court of referral. So matters are not directly sent to the court. They are referred by the commissions to the court if there is a dispute. So that's why a number of departments would have to look at this proposed recommendation and said what it is possible for the state to implement. The second question related to minority, or rather I will call it perspective, alternative perspectives as the owners of the report call it. Obviously it's there in the report. Those areas of disagreement are there. So when we look at the entirety of the report, we'd also look at those different perspectives that have been brought by the two members of the panel. The third one related to Ingonyama Trust, we would indeed look and reflect on what the recommendations are saying, and government will make its pronouncement in that regard. But I just wanted to deal with the issue of the compensation policy, why, in my view, it is an important area that I think we have never been engaged to. Because if you look at the current wording of Section 25 in the Constitution, subsection 3, talks about, what you need to take into consideration when you determine just and equitable. It says you need to look at the land, look at the developments that are on the land, you need to look at the subsidy that the state might have put to capitalize that land. The truth is, when dispossession happened, nobody valued the land where people were staying to say, this is the value. So it was just a proclamation, people were removed. Secondly, no one can track what subsidy was put from the original farmer to the subsequent farmer who followed, and so on and so on. So it will be very difficult to trace the value of subsidy that the state might have put to support those farmers who were settled after, land was taken away from other communities. It is for that reason that those who have called for the amendment of the Constitution are actually saying, though you may say it is there, but it's very implicit, it's not explicit. For instance, your people who are in the space of valuations as property values, they use the value. So you'll need to determine what is the value that is said to be just and equitable, so that they are able to determine when they actually take into consideration the valuation of property. So that is why, in my view, the proposal that is being made by the panel is important, so that we can, all of us, determine correctly what is valued as just and compensation. Thank you very much.
Thank you very much. I don't know whether there's still any last round. Safe to say that the report is already online in the GCIS website and in the department's website. The members of the panel will be available for interviews. I think GCIS will coordinate that. But unless there's another burning question that the colleagues want to make.
As is familiar as one in Cape Town, Marianne. Hi, good afternoon, Minister. Sorry, it's Marianne Merton.
Yes, Marianne.
From Africa again. My questions very specifically dealt also with white paper processes. What happened to the other two white paper processes we had?
Yeah.
Are we looking at a new white paper process? What are the deadlines? How do you see to coordinate all of that? And the very important point that was brought up, given that there is a very clear statement with regards to a broader land reform compensation landscape, for want of a better word, what will you do now with regards to some of the controversial laws that have been mentioned? Thank you.
Thank you.
That's the last round. And then is there any one last pending question? Because this is final. Nothing.
I just want to add what we say on the white paper.
Okay.
Just to also assist in terms of the white paper, the recommendations deal with immediate recommendations where we believe as soon as we leave today, the department can address some of the issues without delving into serious legislative processes which take time. But we specifically gave the white paper process a deadline of by 2021. We should have it, because we recognize that some of the proposals that we're putting forward are going to require a process. But I'll get the minister to deal with that. I just wanted to indicate that in our report, we do specify the time frame as far as this new white paper is concerned.
Thank you very much, Marianne and members. As you hear from the panel, their proposal is 2020. Obviously, as government, we'll have to reflect on that. That's why we've got the 2 months, because we'll have to look at what is there. As you have said, that there was a process that was initiated, I think it was Minister Nkwinti,
yes,
which really was looking at your tenure reform in particular, to deal with issues of communal tenure and how you have I would say, multiple tenural system that is recorded in South Africa and can actually be codified into law. So we'll look at that, because white paper is really about policy reform. So it's looking at what it's happened today, what has been in the past, what are the new trends that are emerging, also looking at the proposals that are coming from the Commission, and say, what will be the process of ensuring that you come up with a land policy for South Africa today? Thank you.
Thank you very much, Minister, and to the Chair and the members of the panel. We have come to the end of this briefing. As I said, if you require any one-on-one interviews, we will facilitate and coordinate that. The report is available as we speak on the GCIS website and the Department of Agriculture and Rural Land Reform.
All right, it is an important story, so that's why we spent so long on it, getting some of the detail coming through. Lots has been said. It's the final report that we have is about 144 pages. So let me try and break it down for you, give you a bit of perspective in terms of what was said here. So the panel, as well as the Minister of Agriculture, Land Reform and Rural Development, Thoko Didiza, unpacking the contents of this report in Pretoria. Remember, the panel was appointed by President Cyril Ramaphosa in September 2018 to provide a unified policy perspective on land reform. Also, to support the work of the Interministerial Committee on Land Reform and to advise the IMC on a broad range of policy matters associated with land reform, including restitution, redistribution, tenure, security, as well as agricultural support. Now, the report makes a number of findings on the current status quo and makes recommendations, as you heard, that will assist in accelerating the work of government in redressing the historical land distribution imbalances. So some of the pertinent issues, salient points that came out of this report, and it was delivered in large part by the panel chair, Vuyo Mahlati, and she was talking about finance. It's a key issue here, finance of land reform. And she was saying that government alone can never address this. So there needs to be this partnership. She also spoke about a call for the reform of the Land Claims Court. And she recommended that it should be renamed as the Land Court. In terms of land corruption, a big issue, a very important issue to be dealt with. And she urged government to improve oversight as one of the mechanisms and try to put paid to corruption, and also called for greater openness and transparency. And she also mooted this call for a land rights protector. My assumption is that it will be akin to the public protector's work in trying to deal with certain allegations of corruption. So important call there. Also recommended is that land reform be extended, and this is a key one as well, to urban land with the aim of creating this inclusive towns and cities here in South Africa. And also land donations, a key issue that has been dealt with. This call to form a land and agrarian reform agency in order to deal with this as well. So, in a nutshell, the aim is to implement a fair and equitable land reform process. So Parliament, remember, will also need to debate and finalize the expropriation bill, which deals with the modalities, I guess, and the circumstances in which expropriation will take place. Much more analysis, not only on the agenda, but on point as well, and the rest of the shows on SABC News.